Evening, Carla Hartley here. It is Thursday night, June 11th, and we are continuing to see the court's phased reopening. And with that phased reopening, we're realizing that we are running into some significant problems in terms of timing and availability of judicial officers. I'm going to explain that as quickly as I can and go past that to some of what we are doing to help our clients get through this without having to wait quite so long for a judicial officer. So I'm going to describe first the priorities that the courts have to abide by per statute and court rule when they are setting matters for trial. Okay, the first and most important thing are your criminal trials. I've mentioned this before. Criminal proceedings have huge constitutional implications, and they float to the top of the water every single time. Then the next thing is going to be, for the most part, your family law matters involving domestic violence or any other kind of restraining order. The most important, not the most important, but as far as the legislature coming from Sacramento, signed into law by whatever governor was in place at the time, is concerned, the priorities that have been set are as follows. You start off in the family law courts, domestic violence with children. Those are going to take priority first. Domestic violence with custody trials. That's going to get the judge's attention first. After that's going to be some kind of restraining order that does not involve children. It can be a domestic violence case that does not have a custody trial attached because kids are out of the house. Could be an elder abuse restraining order, could be civil harassment restraining order, but it's going to be in that neighborhood. Then after those, the court is required to prioritize custody trials. Just your normal custody trial, no domestic violence involved. And I don't want to just say normal. Every custody trial is got a lot of stuff in common, but it also has a lot of things that are different depending on the facts of each case. So if it involves children and there's a custodial dispute, that's next up. Next, we're going to probably have support, okay? Child support and spousal support. I know we have a huge backlog just in our office of cases of actions that we are filing for modifications of support, both child and spousal, and to establish new support orders. 3 months is an eternity, I think, in judicial years, and the backlog is just going to be incredible. If I'm looking at it from my office, we are one office. We're a good office. We are efficient. We do our stuff well, but we still have a backlog because we have not been able to file this stuff. We're in the same boat with everybody else, and we've got our stuff queued up and ready to send tomorrow. So, what comes next? In the priority list at the very, very, very bottom is going to be family law trials involving distribution of property. And again, your judges are not doing this. Your judges are doing what the law says they must do with regard to prioritizing their cases. Our judges must follow the law. They do not create it. I want to be really clear on that. Don't blame your judges for this. So our property trials are next. What can we do to help wrap this up? We're hearing that we're not going to have a property trial in family law probably until January of 2021. That's daunting for many people who want to get on with their lives. What are we going to do as an office? We're going to do what we always do. We settle most of our property cases. We know the law and we know the facts. If we can fit the facts into the law, we can make this generally go to settlement. Most of our cases do settle because we're good at what we do and we know how to marshal the evidence. Those cases that don't settle, for the most part, needed to go to trial either because there was an important issue of fact or law that we could not get the parties to agree on, or one party was just so entrenched in an unreasonable position that it was either let our client be screwed or go to trial. That's when we're headed to trial. So back to settling. How can we prep, even if we're going to trial in 2021, we can be prepared for trial and we can make sure that we're ready to go the minute the clock ticks over on January 1st, which is a holiday, so January 2nd. So what do? The first thing we're going to have to look at dividing is generally businesses. If there's a business involved of any kind, big business, small business, that business is going to have to be evaluated to come up with its value, and it's going to have a determination as income available for support. So we use forensic accountants for that. We have used that. We've worked with a number of those, and we've done this for all sorts of business. Radio stations, we've done construction companies, you name it. Big business, small business, all sorts of things. That has to be valued and figured out, unless it's not actually a business, it's more of a hobby, in which case evaluation is not required, or it's more of a one person, it's really your job. So we handle that. The next thing we're going to have to deal with is the property, even though a business is property, the things people accumulate, some of which are fabulous. Okay, we have got to appraise real property, whether it's commercial property or residential property. If it's vacant property, we still have to appraise that. So we get experts to do that. Most of property is a numbers game, and we have to have the numbers. And if we do our work appropriately in the lead up to trial or to settlement, the same numbers are there. The numbers that we're going to go to settlement with are the numbers we're taking to trial. The experts that we're producing for settlement are the experts we're generally producing for trial. This saves the client money, it saves the client time, and it ensures that we are dead on and not playing games at any point in time with our clients' lives and their property. So that's appraising property. Well, you got to appraise your real property, like I said. We also have appraisers for, we've appraised a classic vehicle collection. We've appraised or gotten an expert to appraise a motorcycle collection. I think the saddest one ever was a doll collection, because husband just wanted his pound of flesh. And so he spent lots of money on getting a guy to appraise a doll collection, and he was an expert, and the doll collection was worth less than the appraisal. So I guess it was worse for him than it was for our client, but it was sad. That we generally discourage that, and it wasn't our client pushing that. And I have digressed. So after we have the numbers, what are we going to do if our clients want to get done? First of all, sit down with opposing counsel and work out a settlement based on the numbers and what we know the court would do. If we have a triable issue of fact, say there's just one thing that the parties are really disputing, we have a couple of avenues that we can take. We can work with a private judge. That is something that is always a good option and doesn't require waiting. And sometimes it's a lot less expensive for the party. That seems counterintuitive, but that can be a good option. Because it costs a lot less in terms of rescheduling and working around the public court's needs and the stop and start that you sometimes have in a public courthouse. So that's the rundown on that. I realize I got into a lot of stuff that I could really go much more in depth on. So I think next week I'll talk a little bit more about the forensic accountants and valuation of businesses and determining income available for support. So I'll talk to you next week, because those are two of my favorite topics. Bye.